Hi, and welcome to the Innovation Game, a podcast by the IP law firm Potter Clarkson. My name's Rich Wells, and today we're going to be talking about the Unitary Patent and the Unified Patent Court. I'm joined by Dave Carling, partner and patent attorney in the Pharma Life Sciences Group, and Graeme McCallum, a partner and a patent attorney who works in computing and electronics and with investors. Firstly, it's important to put a bit of a timestamp on this podcast. I know normally our podcasts are fairly timeless, but the UP and UPC, which we're talking about today, is a bit of a fast-moving juggernaut. So just to note, this is recorded mid-July 2022, and things may have moved on by the time you listen to it. So to start with, we live in a world of acronyms. UP, UPC, what does it mean? Dave, do you want to take UP first?
Okay, UP is the Unitary Patent. This is a brand new patent right. It's a single patent right that covers anywhere between 17 and we think about up to 24 countries in Europe, depending on the date on which it's granted. It's going to live or die across all of those countries in one go. So it's quite different from the existing European patent system. We can certainly get onto the details of that a little later on. But yes, it's a single patent right coming out of the European Patent Office.
Okay, cheers, Dave. And over to you, Graeme, for the UPC. What's that?
Thanks, Rich. The UPC is the Unified Patent Court, and this is a new international court that is in the process of being set up, and it will have exclusive jurisdiction to decide cases, litigation surrounding unitary patents. But importantly, it will also have jurisdiction over conventional European patents as well. So patents that have already been granted and nationally validated in individual countries. These will fall within the jurisdiction of the Unified Patent Court, the UPC as well, unless you take the opportunity to opt these out.
Okay, and we're going to talk in a bit more detail about what this means for applicants of in Europe and patentees. But this is obviously not started yet. What is the timeline that we're working to here? When's it expected to start? When do people need to make decisions? Graeme, have you got any thoughts on that?
Yeah, actually there was quite timely, Rich, but there was a meeting of the UPC Administrative Council, I think last week, and they have given that the latest indication of when the UPC and the UP are due to start is likely to be early 2023. So previously, it had been a bit vaguer. They'd been talking about end of this year, possibly early next year, but it seems to be that it looks now as if it's unlikely to happen this year. It looks like it's likely to come into effect early 2023, with the sunrise period starting roughly 3 months before that.
Okay, we might talk about it in a bit more detail later, but you mentioned the sunrise period. What does this mean for people who want to use these schemes?
So the sunrise period will start when Germany deposits its ratification and will last for just over 3 months from when Germany deposits its ratification. And the sunrise period is primarily gives applicants, proprietors, the opportunity to opt their patents out of the UPC. So this would be their nationally validated European patents, to opt them out of the UPC jurisdiction prior to the UPC coming into effect, which would prevent other parties challenging their patents by filing for applications for revocation on day one of when the UPC comes into effect.
Okay, so Dave, if you've got any thoughts on this, it seems that whilst the UPC schemes will start at the turn of the year, decisions need to be made sooner than that.
Absolutely, they do. I mean, one of the things that has always struck me through this process as the law's been developed is it is a change to the status quo for all patent holders. I mean, usually when laws change, you know that if you do nothing, things will carry on as they are. But this is very much the opposite to that. If you do nothing and you're a patent holder, your patents are now put into the system and they become vulnerable to revocation at the UPC. if you don't like that concept, you have to be proactive, you have to opt out.
Okay.
And to secure your sort of that the guarantee of not being vulnerable to revocation centrally, you want to take action during that sunrise period.
So there's obviously the two parts of this. There's the Unitary Patent, the UP, and the Unified Patents Court, the UPC. Both of these will need to be considered. Diving into the UPC first, Graham, we briefly talked about opting in and out, but what's the pros and cons of this? What does it mean for applicants and patentees?
Thanks, Rich. Well, the advantage, the pros of opting out is that your patent, your national European patent validation will not be subject to the jurisdiction of the UPC. Now, why would you want to do that? Well, you might want to do that to take your patents out, especially valuable ones, until you see how the UPC develops, how the case law develops. And I think it's important to note that this is a new court, it's a new international institution. Nobody quite knows how it's going to operate in practice. The judges and the combinations of the judges aren't really that well known. There will be some judges that come from countries that don't have a long history of patent litigation and will need to go through training. There is also not going to be, when the court starts, there will not be any case law established either. So the court system from day one is going to have to start to establish its own case law. And for that reason as well, because there is no jurisprudence when the court starts, patent proprietors may wish to take a back seat and see how the case law and the court develops in practice before deciding whether or not to participate or deciding when to participate. Now, the downside of opting everything out is that you're not involved in the court, you don't get experience of how the court operates, and you don't have an opportunity to shape the case law either. Whereas if you don't opt out, if you keep your patents in that system, then you're going to have more opportunity to be involved in the case law and to shape the court as it develops.
Again, we're sort of talking about, say, a pan-European revocation as being a possibility at the court if you're a patentee. But I guess there's the advantage as well as of having relief that spans the whole of the jurisdiction, such as an injunction. Is that correct?
Yeah, yes, that's absolutely correct, Rich. And one of the downsides of the court for a patent proprietor is that there's the potential to have a pan-European revocation action, so that the whole of your European patent, at least for the UPC member states, goes in one fell swoop. But the other side of the coin is that you also have the opportunity as a patent proprietor to get pan-European injunctions, pan-European relief across all the UPC member states in one go as well.
So it's not purely a box ticking exercise, is it? It's not one size fits all. There's a lot of things to consider: the commercial sort of reality of things, the appetite of risk that you may have as a applicant or patentee, and also potentially the field in which you're in. So Dave, Graham, you both come from different patent attorney worlds, and you'll be having had conversations with your clients in the pharma field, Dave, and telecommunications, Graham. Are there trends emerging on the strategies that people you're talking to in your world are following? Dave, do you want to start?
Sure. From my side, there definitely are trends. I work both with large pharmaceutical companies and some, very small companies, and in pretty much all cases, you can very often see they have a product that just has one or two patent families around it, and these patent families are absolutely critical to the businesses. Absolutely critical. These crown jewels of IP for them have to be protected as they see it. So their appetite for risk, as it were, is very low. They don't really want to engage with the Unified Patent Court, given all of the uncertainties that Graham's just said. So they are more inclined to opt out these high-value patents of theirs. That's certainly not the case for all companies or all patents that they have. I mean, the examples that I've been sort of had when I've been talking to clients have involved cases where, yes, they have their most important patents, which they do want to opt out, but other patents they're happy to keep in where there's lesser value, because, as Graham said, they do want to help shape the case law of the court in certain cases, but in more cases it seems likely that they just want to be more familiar with the procedures, the costs and the timings, and to learn more about how it all works and how things shake down in real life. Because at the end of the day, everybody is going to be part of this once the transition period ends, and you have to be prepared to, get stuck in with litigation, revocation actions and enforcement.
Yeah, I suppose you don't want a bad set of case law to be jeopardizing your future crown jewels if you're one of the big players, do you? I suppose that's not what you want. So over to you, Graham. In your world, people you're talking to taking a similar approach, or have they kind of got different strategies in mind?
Very much different strategies, Rich. Some of the strategies are similar to the strategies Dave mentioned, but some of them are quite the opposite. And a lot depends on the business strategy of the particular client and the proprietor. And the size of them as well. So some of telecoms clients, telecom sphere, they're huge companies. They have huge portfolios of standards essential patents. If you look at Qualcomm, Nokia, Ericsson, for example, Nokia has over 4,000 patents declared as standards essential for 5G. Now, if you've got a portfolio of over 4,000 essential patents, perhaps it's not quite so important if you lose one or two or maybe even 10 or 20 of them. And so your portfolio can withstand that. But there will be also smaller players in the telecoms field who perhaps have less standards essential patents, and they'll be maybe thinking about opting them out. There may well be players in there who perhaps have only 10, 20 standards essential patents, and you can see that in that scenario, their crown jewels, it's a much higher risk for them to at least keep it within the UPC initially, and they may decide to opt out a lot of these cases. So it very much depends on, I think, the business strategy and the size of the corporate concerned.
So yeah, you can really see that there isn't one size fits all. It'll very much depend on the company itself. And Graham, mechanistically, we've talked about the strategy, but mechanistically, what does opting out, opting in mean? What do you have to do? Are there any costs involved?
The opt-out process is relatively straightforward. It can all be done online, and there is a bulk system that the UPC has enabled on their IT backend to enable to do that, to opt out a large number of cases simultaneously. So in terms of fees, Rich, there is no official fee for opting out, and Potter Clarkson don't charge a fee for opting out for the recording the opt-out, provided that the case is relatively complicated. If there are more complicated cases, such as assignments or change of title that have not been registered, then there may well be a fee for that, and that makes things more complicated because the actual proprietor needs to be checked.
Yeah, I think that makes sense. I guess, yeah, often with complication comes cost, I suppose, the way of the world. So I think that's given a really good overview of the Unified Patents Court, the UPC. But there's obviously the other side of this, in simple terms, the unitary patent. So Dave, can you just give us a kind of an overview of the basic, the procedure, that involved in getting a unitary patent, and what countries does it cover?
Sure. Procedurally, the unitary patent is not a difficult thing to obtain, because you carry on as you already do now with the European Patent Office route. The only thing that changes is what happens after grant. The existing procedure after grant for a European patent is that you validate in whichever countries you choose within 3 months, and there's translations involved, and it can be quite a costly procedure if you're going ahead in the maximum number of countries, which is some in the region of 38. When the unitary patent becomes available, we know that the very first unitary patents will cover at least 17 EU countries. It could go higher, and we hope certainly that it will go higher in due course once more countries join the system. But initially, it will be 17 countries, and that'll include big hitters like France, Germany, and the Netherlands. There's a slight difference in the procedure in that you have to prepare a translation, and you have to do this within 1 month of grant. So everything's brought a little bit forwards in time, but that's the only real difference. For those countries that aren't covered by the unitary patent, like the UK, Spain is not in there, Switzerland, anywhere outside the EU like Turkey, those aren't covered. Those you have to cover with the normal national validation route. So the 3-month period still applies there, translations are needed and fees are needed. But there's quite a considerable cost saving if you are the sort of patent holder that likes to validate in a lot of countries, because there's only one translation needed. And the choice of language, it's if you're filing in English, then you have any EU language to choose from. So if you have a European patent that's prosecuted in English and you're already validating in Spain, your Spanish translation is good enough.
Okay, yeah. So I think there are definite cost savings there. And moving into, say, the pros and cons, what are they?
The pros really do come down to cost. At all stages, there's the cost on the validation side, which means greatly reduced translation burden, greatly reduced official fees. You don't need foreign agents in all the countries. So there's an instant saving there. And throughout the lifetime of the patent, there's also savings in terms of renewal fees. And the renewal fees that have been calculated for unitary patents roughly equate to 4 countries worth of fees. So if you would normally validate in 4 countries or more that are covered by the unitary patent, there's a good chance of a cost saving for you here. As I say, UK is not covered, Spain is not covered, so quite a lot of our clients do tend to pick 3, maybe 5 countries: UK, France, Germany, Spain, and Italy. They probably fall the wrong side of the line for a fee saving, to be perfectly frank. But for anybody that wants more than those main 5 countries, there probably is an excellent cost saving throughout the lifetime of the patent. There's also obviously the benefits that if you choose to enforce and you're successful, you will get a pan-European injunction across all of those EU states.
And that's because, I guess, if you've got a unitary patent, it's unavoidable. Well, the Unified Patent Court is unavoidable, isn't it? There's no opting out a unitary patent. They're in whatever, aren't they?
That's right. It only goes through the Unified Patent Court for enforcement or for revocation. That's another good point, actually. In terms of revocation, your patent that arises out of the EPO is still vulnerable to an opposition at the EPO, regardless of how you validated it nationally. That 9-month period still applies. Anybody can seek central revocation across all 38 countries. And we certainly expect opponents to keep using that route because it covers all 38 countries. It'll revoke the patent potentially, even if it's a UP and even if it's validated in Spain and UK.
I think that is key, and it's, as you said earlier, the UP isn't this strange mystical beast that's kind of come out of the mist and there's no real knowledge about it. It's basically what you have now, a European patent up until the point of grant and including the opposition period. And it's really what happens beyond that that's new. And I think those that are familiar with the classic, the current system of getting a European patent, it won't be that different, will it, at all?
No, not at all. The procedure out to grant is completely unchanged. There's no new designation fees or anything like that. It's the procedure after grant that's different, and really the pros come down to a cost saving. The cons come down to having a single patent that for its lifetime can be revoked in totem. So that the whole thing can die at the Unified Patent Court in 10 years' time.
At least within, I guess, the countries that are a member of the UPC. If you've got a, say, separate UK patent, that would be safe, right?
Interesting point. Yes, if the UPC decides to revoke the patent what will actually happen is that the unitary patent designation dies. Now, whether that decision carries any weight beyond the UPC countries will depend on those courts in, say, the UK and Spain. But to be fair, they probably will give it quite a bit of weight. We're still yet to find out about that.
But I suppose that comes back to what Graham was saying. It's such an unknown about how these courts are going to make their decisions and the ramifications down the line, both for revocation and say injunctions and the like.
We could talk endlessly about how they might be hearing evidence and hearing from witnesses and so forth. So, yes, a UK court could come to a very different conclusion from a UPC on infringement or validity. We just don't know. Okay,
and just as a almost an umbrella topic that I'm sure some listeners will be thinking about. Patents they're a piece of property. They're bought, sold, and most importantly, they're licensed amongst companies, and that's often very important for the way that companies make their money, commercial decisions. Are there any licensing considerations here? Will the sort of the birth of the UPC change what needs to be done in relation to licenses? Dave, have you got any thoughts on this?
Certainly, it very much does change things, both for existing licenses and for any agreements that you're trying to sign in the future. The opt-out question is immediately in my mind at this point, because it may be that the patentee is quite happy to leave the patent vulnerable to central revocation at the UPC, but the licensee isn't. Now, the licensee would prefer an opt-out in those circumstances, but maybe doesn't have any control to file that opt-out because they're not the patent holder. I mean, you can also see the converse position arising when the licensee doesn't want an opt-out, but the patent holder does. But maybe the patent holder is obliged through the terms of their license agreement to consult with their licensee and come to an agreement with them over how a big decision like this should be made. So anybody who's a party to one of these agreements needs to be careful and take a good look at their agreements and make sure they're not treading on anybody's toes and not withholding rights from people when they make decisions to opt out or not opt out. Yeah, a second quick question is, do the existing licenses that you have adequately cover and allow for the existence of a unitary patent in the first place? They probably only refer to European patents by name. They may refer to protection by country, but a unitary patent is quite different. There's also going to be jurisdiction clauses in pretty much all commercial agreements, and these need to be reviewed because the UPC is a brand new court. It's a brand new sort of area of jurisdiction. So everybody needs to be certain that their licenses are fit for purpose, and if they're not, maybe some agreement needs to be made to supplement it. So I would definitely say, if you're a licensee or a licensor, or you're engaging with partnerships in any way like this, have your licenses reviewed by somebody like the team we have here at Potter Clarkson, who are absolutely expert in all of this, to make sure that it's future-proof for when this comes into effect in January.
Certainly worth opening that filing cabinet and pulling out the licenses and dusting them off, at least for a cursory review.
It may lead to some awkward conversations. I mean, we've been talking with parties where they have multiple license agreements based on a single patent. So a certain field of technology within that patent is licensed to one company and a different field is licensed to another company. That's still possible under the UPC, but now you have lots of people to try and keep happy. And if they want different outcomes for the opt-out question, some difficult questions and difficult conversations may need to be had.
Yeah, there's one of many things for people to consider. So I've obviously covered a lot of ground today. If our listeners are going to take home some key points, what do we think they are? I think for me, one point would be thinking about what Graham said. The decision about opting out isn't an easy one. We people do need to start thinking about this now, really. Graham, what would your take home message be?
Well, I absolutely agree with the opt-out strategy point, Rich. And bear in mind as well that it's not something you want to leave to the last minute, to the end of the sunrise period, because it may well be that the IT systems at the UPC will become swamped in the last week with everyone trying to opt out their patents. And if people are trying to opt out 3,000 or 4,000 patents at a time, you could quite quickly see that the IT systems could become swamped. So really, you want to be thinking about it sooner rather than later. Also, start thinking about how you want to use the unitary patent. Do you want to use it, or do you want to continue with national European national validations? Bearing in mind that European national validations will also at some point come under the UPC. Do you want to think about national patent applications as well, filing national patent applications in certain territories so that they will always be outside of the UPC?
There's a lot of strategic consideration, certainly. And Dave, lastly, what would your take home be?
Both of those, the question about the UPC and unitary patent, absolutely. In addition to that, I would certainly say thinking about your licenses. It's a sort of question that is not always discussed. It's not always thought about, but so many of these agreements are fundamental to how businesses work, and they sit in the background, never to be thought about again. It's just worth casting your eyes over those to make sure they're all in order.
Great points. We'll end it there. So, Dave, Graeme, thanks so much for your time.
Thank you, Rich.
Thanks, Rich.
No problem. And thanks to the listeners for tuning in. This has been the Innovation Game, a podcast by the IP law firm Potter Clarkson. You can hear this on SoundCloud, Spotify, and YouTube. And for more information about Potter Clarkson, visit www.potterclarkson.com, and on there we've got the UP and UPC hub, which will hopefully provide a bit more of a deeper dive into the issues that we've discussed today. Thank you for listening.